हाँ.
And first case.
Time is something specific. Serial 7 case number. 2276. 2276.
Yes.
Counsel for the petitioner seeks permission to withdraw this bail application. Accordingly, this application is dismissed as withdrawn.
Fine.
Your name is Divyanshu.
Divyanshu Krishna.
From date is Professor and Attorney DT.23.03.2026. of 2026.
You are there? Are you there? Asif.
Item 3, DA2249 of 2026.
Short passover for 2 cases. Just I heard.
Counsel for the state is directed to file a counter affidavit along with antecedent report and the injury report of the victim. Get the case diary report from the concerned court, communicate, post this case on the DT.
Item 4, DA2262 of 2026. Item 5, DA2265 of 2026. Item 6, DA2272 of 2026. Item 8, DA2278 of 2026. Item 9, DA2299 of 2026. Item 10, DA2301 of 2026.
Are you there? Counsel for the petition is present. Counsel for the state is directed to call for the report. Let the report from the FSL report be called for. Let this order be communicated through fax to the concerned. इसमें काउंटर आ गया है?
इसमें नहीं आया.
State to file counter affidavit along with criminal antecedent report of the petitioner. Let the case diary be called. Date वही 13th April.
Item 11,
13th April 20 April.
Item 11, DA2308 of 2026.
Are you there? In this case? आपके हिसाब से केस नहीं फॉलो होगा. पास ओवर है, पास ओवर के समय आएगा. पास ओवर के.
Item 12, DA2314 of 2026.
पास ओवर.
Item 30, DA2319 of 2026.
Passover. Counsels are not here.
For admission, item 14, BA 9696 of 2025.
पास होगा शॉर्ट पास ओवर नहीं सब एक साथ होगा पास ओवर उसी समय आएंगे and you have to wait for your turn
Item 15, BA 10915 of 2025.
पास ओवर
Item 16, BA 10958 of 2025.
The officers are section 109 of BLS and 127 of the arms.
खाली read there FIR
The FIR clause is at page 15.
please
निवेदन पूर्वक कहना है कि मैं दीपांकर कुमार सो आज दिनांक 1/6/25 को समय 7:30 बजे लगभग मैं अपने घर के दरवाजे पर खड़ा था। तभी दो बाइक में 6 की संख्या में the name of the petitioner and other accused person निगम के द्वारा आज दिनांक 1/6/25 समय 7:30 बजे शाम को मेरे घर पर आकर मेरे ऊपर गोली मोहित प्रमाणिक के द्वारा जान से मारने के नियत से मेरे ऊपर चलाई, जिसमें मेरे दाहिने पैर के घुटना में गोली लगी है। मैं DMH अस्पताल में इलाज करवा रहा हूँ। मतलब विमान से निवेदन है कि मुझे लोगों पर कानूनी The allegation of firing appears upon the petitioner clause, and it is the case of the prosecution that the injury was caused on the right leg muscles, and there is no repetition of any firing. And so far the injury report is concerned, the opinion is reserved. Till date, the injury, whether it is previous or not, that has not been.
DA number 10958 of 2025
Custody. Is in custody since 3/6/2025. Though the charge was filed way back on 14/10/2025, but till date not a single witness has been examined. Altogether 25 witnesses have been cited in the charge.
where is the injury report state sir
कोई फाइंडिंग नहीं है। पैराग्राफ
गोली
47
लगी नहीं है क्या
of
विक्टिम को गोली लगी नहीं है क्या
नहीं लगी है, बट सो फार इंजरी का फाइंडिंग नहीं है, whether it is simple or previous, that is not there.
but the learned counsel opinion yeah
And it is not on the vital part of the body.
the learned counsel for the petitioner submits that as per the allegation the petitioner had hit the victim by firearms which hit his leg and till date there is no injury report as to whether the injury was grievous or severe. The petitioner is in custody since 3/6/25. The charge was framed on 14/10/2025 and till date no witnesses been examined. The learned counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner. After hearing the learned counsel for the parties and considering the nature of allegation which is direct against the petitioner of firing with using firearm, this court is not inclined to enlarge the petitioner on bail. However, from the records of this case, it appears that there are as many as 25 witnesses in the charge sheet. And the case is pending for examination of witnesses. The state is directed to ensure production promptly produce the witnesses.
Some liberty.
That is always there.
Item 17, DA 1100 of 2025.
Your Worship, in this case, some witnesses have been already examined. So I was paid for 2 weeks time to bring them for the depositions. बेटा बहुत दोनों को चला के मारा.
इसमें क्या deposition? Deposition के आधार पे भी आपका some witnesses have been examined. I will expedite your matter. That should be sufficient. You should be happy with that. You have asked. Who are you?
I am the father of the
Father-in-law.
father and father-in-law of the deceased. बेटा बहुत दोनों को जला के मारा.
How many witnesses have been examined?
13 witnesses have been examined out of 25. 23 out of 23. Fifteen have been examined, Your Worship, out of 23, and the last was examined on 5th February 2026.
And out of them, some of them must be official witnesses. No postmortem, doctor, आयु, यही सब.
नहीं,
आयु वगैरह सब एग्जामिन हो चुके हैं.
अभी नहीं.
मतलब जो बच्चे हैं उनमें से ऑफिशियल विटनेसेस भी होंगे काफी.
हाँ, उसमें से ऑफिशियल
विटनेसेस काफी होंगे.
काफी.
Heard the learned counsel appearing on behalf of the petitioner. Nobody appears on behalf of the state. Counsel for the petition submits that the petitioner is in custody since
23/6/2024.
since 23/6/2024, and he has been falsely implicated in this case. It is alleged that the petitioner has killed the son as well as daughter-in-law. During the course of hearing, it transpired that date 5/2/2026, altogether 15 witnesses out of 23 witnesses has been examined. Counsel for the petition has submitted that many of the remaining witnesses are official witnesses to be examined. After hearing the counsel for the petition and considering the serious nature of the allegation, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure production of witnesses. Counsel for the state is directed to communicate this order to the Director Prosecution and also to the Superintendent of Police of the concerned district to ensure compliance. Since the counsel for the state is absent, let this order be communicated to the Office of Learned Advocate General to ensure compliance.
Some time to
टाइम नहीं दे सकते मैडम. अब सुन रहे हैं जैसा कि जितने भी ऑर्डर्स हो रहे हैं प्रोडक्शन ऑफ विटनेसेस का, दे आर बीइंग प्रोड्यूस्ड. थोड़ा सा एक्स्ट्रा स्टेप लेके कर देते हैं तो ठीक है, जो होगा ट्रायल में हो जाएगा.
जी.
यही तो पर्पस है और क्या.
Item 18, DA.23.03.2026 of 2025.
यस बताइए. 10
108 of BNS. 306 of Board CR. This case is marriage of online road.
read the FIR please.
Yes. Page 16 also.
Yes.
लीडर को मैंने मैं मोहम्मद खान का सत्तू खान ग्राम गोविंद थाना करकमसानी ग्राम कोपी जिला हजारीबाग का अस्थायी निवासी हूँ. वहाँ से मैंने अपनी बेटी मेहर पर भी 29 वर्ष की शादी के विवाह के अनुसार इनाम 20 को राय अंसारी मोहम्मद अंसारी और 22 वर्ष पिता इब्राहिम अंसारी ग्राम गोविंदपुर पोस्ट कंचनपुर थाना करकमसानी ग्राम कोपी जिला हजारीबाग के रहने वाले के साथ किया. शादी तय होने के समय लड़का एवं उनके पिता और तीनों की तरफ से कहा गया कि हमें दान दहेज देनी चाहिए और अपनी बेटी दीजिए. लेकिन शादी बरकरार होने के बाद भी मेरी बेटी को दहेज किया जाएगा और ये बताया जाएगा जाओ अपने बाप से 2 लाख रुपया और मुझे कुछ लेकर आना, नहीं तो मेरे घर में आना, खाली आप आगे की काम से मार देंगे, मेरी बेटी मेहर करनी ये सारी बातें तुम करके अपनी माँ को बताई, उसके बाद माँ ने समाज के अनुसार सलाह दिया, ये करके मेरी बेटी हमको सही करनी है, इतना खतरनाक बनाएंगे, जो तुम मान गई, फिर कुछ दिन बाद फोन आया करके बताती है कि मतलब बात होने लगा है, मेरे पति और मेरे ससुर भाई गाड़ी का सॉरी आपको बता दें मेरे पैसे बहुत वाले वाले मैंने थाना में कुछ सालियां था मेरी सास ये मारपीट करने के मां से शिकायत की
आप कौन हैं?
हम हस्बैंड
Counsel for the petitioner is present. The learned counsel for the petitioner submits that.
one thing independent witness has been examined and they have said that the petitioner he himself has tried to save his life by breaking the roof of the house blood. In case of a mental blood, and you also find there is no incitement, and there is no motive behind that. There was a love marriage between parties, and at the time of marriage, no demand was made. And two witnesses have been examined by the Bureau of Blood, and their discussion I have.
They have not supported that proceeding.
Like my independent witnesses are not supporting this.
Okay, we'll see that. Very serious allegation. 1 महीना में लड़की मर गई है घर के अंदर, काफी है।
हमने कुछ से कोशिश किया, छत पे चढ़ के दूर कर गया।
मरने के बाद तो सिर्फ
वो इंडिपेंडेंट मिनिस्टर से साफ-साफ कहा है। इसकी गवाही
नहीं ऐसे गवाही देखकर यहाँ पर ट्रायल थोड़ी चल रहा है। ये नंबर 1148 of 2025. For the learned counsel appearing on behalf of the petitioner, the learned counsel for the petitioner submits that the petitioner is the husband and had married the victim to love marriage. He has also submitted that at the time of the he has also submitted that the petitioner had also tried to save the victim by breaking the roof of the house. He has further submitted that the independent witnesses have not supported the prosecution case and the trial is in progress. After hearing the learned counsel for the petitioner and considering the serious nature of allegation, the wife of the petition, the marriage was solemnized on 24/2025 and she was found dead in a matrimonial home on 8/5/2025. This court is not inclined to enlarge the petition on bail.
That expect only to that extent. And for the third part, the study.
The state is addicted to prompt use of witnesses in court. और बाकी जो जनरल ऑर्डर होता है कम्युनिकेशन का करना है।
Item 19, BA111514 of 2025.
Request for a possible notice.
Item 20, BA111641 of 2025.
Last occasion also we got the matter and total this case for today to call for CDR.
कौन काउंटर तो आ गया इसमें?
हाँ काउंटर आ गया तो कोई इंसिडेंट का एलिगेशन था कि गाड़ी मांगने का एलिगेशन था फोन नंबर के थ्रू फोन नंबर डज नॉट बिलोंग टू मी मेरे पास से रिकवरी से तो पर्चा का रिकवरी है।
आपका सीडीआर रिपोर्ट आया है इसमें?
हाँ सीडीआर रिपोर्ट मेरा सीडीआर रिपोर्ट का कोई नहीं है मेरा नहीं है।
ये जो हमने सीडीआर का रिपोर्ट के लिए बोला था that mobiles were sent for procuring CDR report, but the CDR report has not been annexed along with the case diary. आया है इसमें? Where is the state? That's it.
Item 21, BA111935 of 2025. Item 22, PA 12052 of 2025.
Mr. Vishnu Purana party to the Army Corps, but due to certain demise was no longer
Counter already filed, and I have submitted the case diary last night.
BA number 12052 of 2025. Mr. नाम बताइए.
Vishnu Purana.
आपका नाम. Sorry.
Arpit Khandekar.
Arpit Khandekar. Mr. Arpit Khandekar, advocate, submits that the argument counsel, Mr. Vishnu Purana Patel, is unable to appear before this court on account of sudden demise of his mother. Uncle. How many days time do you need? So
1 week.
1 week में हो जाएगा अंकल का साथ. Last rites हो जाएगा.
Yes. Teacher.
He prays that the matter be adjourned for a week. Friday को रखिए, कब रखिए? Next Monday रखिए. Friday रखिए, post time. At his request, post this case on Friday. Friday holiday, Monday.
Item 23, PA 12087 of 2025.
Yes, Krishna. Second round में पास ओवर नहीं मांगेगा, हम नहीं देंगे किसी को पास ओवर.
Item 24, PA 83 of 2026.
Earlier rejected and subsequently to the rejection, one similarly situated coercive person has been granted. The prosecution story has
No, just subsequent to the rejection, the co-accused person has been granted bail.
Yes, that has been annexed also.
Just a moment. The rejection order of yours has been considered in that case. I will not consider.
The supplementary paper.
कुछ नहीं सब कुछ नहीं.
Supplementary paper.
Sorry?
Six criminal incident there is single nature.
How many antecedents?
6.
Those who have been granted bail, they have also.
That's what I just, my question was very simple. Was the bail order, rejection of your bail order was placed before the court who has granted bail to the co-accused? No.
No, annexed still.
आपको समझ नहीं आ रहा. जिनको बेल हुआ है, कौन सा भाषा में, बंगला में बोले, जिनको बेल हुआ है, राइट, उनका बेल देते समय आपका रिजेक्शन ऑर्डर उस कोर्ट पे प्लेस हुआ था. हाँ, दिखाइए.
हमारा जो रिजेक्शन हुआ,
आपके रिजेक्शन का बात ही नहीं कर रहे. किसको बेल हुआ? कोई
वो है कि महेंद्र ठाकुर. That is initial to page 30.
पेज
Page 30.
कहाँ लिखा आपका बेल ऑर्डर? आपका रिजेक्शन ऑर्डर के बारे में तो उसमें कहीं नहीं लिखा.
नहीं, हम नहीं है पैराग्राफ.
कोई बात नहीं, समझ ये नंबर आप बेल कम करते हैं ना, इसलिए आपको मेरा सवाल नहीं समझ. कोई बात नहीं. और ये रिजेक्टेड है, कुछ कर नहीं सकते. आपका एंटीसीडेंट बाकी लोग बना देते हैं आपका एंटीसीडेंट.
उनका भी है, हम सप्लीमेंट्री फाइल कर देंगे.
कोई जरूरत नहीं. नॉट रिक्वायर्ड. ये नंबर 83 of 2026. Counsel for the petitioner is present. He has submitted that the bail application of the petitioner was rejected by this court in DA number 8093 of 2025 by the order dated 18/9/2025. He submits that the co-accused of the case
appeared on spot and two others are been granted from there also.
Yes.
One
He-
book and a revolver was recovered.
He submits that
And similarly situated.
altogether 3 persons were apprehended on the spot along with, including the petitioner.
Petitioner
Out of them, two persons have been already enlarged on bail.
And subsequently rejection of this petitioner advocate.
After the rejection of the bail application of the petitioner.
And he is in custody since 12/4/25, much more
The
than the other.
petitioner is in custody since 12/4/2020. Counsel for the respondent has opposed the prayer and has submitted that there are how many antecedents? Six criminal antecedents of the petitioner of similar nature, and the bail application of the petitioner was earlier rejected on merits. After hearing the learned counsel for the parties and considering the criminal antecedent of the petitioner, this court is, and also the fact that the bail application was rejected earlier, this court is not inclined to enlarge the petition on bail. So far as the grant of bail to co-accused is concerned, which is certainly after the rejection of the bail order of the petitioner on 18/9/2025, but the orders do not appear, but it does not appear that the rejection of bail application of the petitioner was placed before the concerned court. However, in view of numerous criminal antecedents, no ground for bail is rejected.
Item 25. B87 of 2026.
Sorry?
The arguing counsel, Mr. Ankit Prabhu, is not available due to personal difficulty. He is playing for this case to be listed next week.
Today he is not available. Tuesday, tomorrow.
Lordship,
He will not be coming to the court for a week.
he went to his hometown because of the check.
Counsel for the petitioner seeks adjournment on the ground that arguing counsel Mr. Ankit Apurva is not available on account of his personal reasons. Post on 20th. B6.
Item 26. DA103 of 2026.
Yes.
Suspicious case, Lordship, from the house of marriage ceremony where the marriage ceremony was going on. Only if her husband has reached to the place of occurrence and seen the accused with the victim, alleged victim. This is very suspicious in nature, and they are waiting for the 2 days for lodging the case. That is also there a lot of cases. The incident took place on 4/3 and the case was registered on 6/3. That is a very suspicious condition, Lord of that. That is my only argument on this case. And because she has specifically stated on the evening she has gone alone at the riverside, and thereafter this petitioner and thereafter her husband came to the place.
What is the age of the victim?
Age of the victim is 21 years. That has come in the FIR itself at page 15, second line.
Her statement has been recorded. Has she supported the case?
183 statement is not there in the probably in the case diary. 180 statement is there.
Yes,
That
it
is the same
Sorry.
argument.
So
The same argument is there.
it is mentioned in the impugn order also.
Yes, okay,
That
that's what
she
I am
has
saying.
supported the case. There is direct allegation.
Allegation is directly lost in the content of the FIR itself.
That's it.
But the circumstances is suspicious.
That's it. BA number that वो benefit of doubt आपको acquittal में मिलेगा.
Then you Lordship, may I permitted to withdraw this application as because if any order
After
has
some
been
argument, when this court was not inclined to enlarge the petitioner on bail, the counsel for the petitioner seeks permission to withdraw this application. Discussed as withdrawn. वो आपका read का order upload कर दी गई है. मिल गया?
Yeah.
साइन कर
Item 27, BA 174 of 2026.
Yes, petitioner.
Yes, madam.
Can I begin?
Three persons were apprehended while they were coming in a ground, and thereafter from my position nothing was recovered. From the position of Kuwait, 250 gram of brown sugar was recovered from Kuwait, and from another Kuwait 8 gram was recovered. But me is concerned, nothing has been recovered. A person whose position 8 gram has been recovered has been granted regular bail by this honorable court.
आपका एंटीसीडेंट है?
नहीं, कोई एंटीसीडेंट
कहाँ लिखी?
नहीं।
लिखा है ना?
जी जी। मेरे नॉलेज में
कहाँ है? कहाँ लिखे हैं?
पैराग्राफ 11 में।
कब से कस्टडी में है? ये क्वांटिटी कौन सा कहलाएगा? स्मॉल क्वांटिटी क्या कहलाएगा?
मेरे पास से कोई रिकवरी नहीं।
कोई बात नहीं, सब मिला के तो
कमर्शियल, लेकिन मेरे पास से कोई
ये आप कैसे बोल रहे हैं आपके पास से रिकवरी नहीं है? सीधे लिस्ट दिखाइए। एफआईआर जरा पढ़ेंगे।
एफआईआर नहीं पढ़ा। पेज 17, पेज 17, 4 लाइन छोड़ के सूचना मिली कि बादल साहू नाम का व्यक्ति गढ़वा से ब्राउन शुगर खरीद के ला रहा है एवं आसपास बेच रहा है। तो सूचना के सत्यापन करने हेतु उपनायक गस्ती चेटर मैदान गुमला पहुंचे तो आसपास उसी समय गुमला बाजार तरफ से 3 व्यक्तियों को अपने तरफ आते हुए देखे, पैदल आ रहे। हम लोग देखते ही तीनों व्यक्ति इधर उधर भागने लगे, जिसमें साथ में सबसे बड़ा तीनों व्यक्ति को पकड़ लिया तथा मंडल पदाधिकारी ने तीनों व्यक्ति बारी बारी से पूछने पर अपना नाम बादल, विकास और तीसरा सुनील प्रजापति बताया। तो अनुमंडल पदाधिकारी महोदय गुमला के तरफ जमा किया गया और बादल साहू सच के जिला रामगढ़ के पास से एक पीला रंग का बैग मिला, जिसके अंदर पीला रंग के पॉलीथीन में 3 पारदर्शी प्लास्टिक पैकेट जिसका वेटिंग मशीन पर वेट करने पर 250 ग्राम पाया गया। इसके डीटी किट से जांच करने पर ड्रग्स श्रेणी पाया गया। इस बार कंपनी का मोबाइल पाया गया, सच 14,000 रुपया का। मंडल की परिस्थिति में सुनील प्रजापति को एनडीपीएस 50 कर नोटिस पहले हुए पॉकेट से एयरटेल कंपनी का मोबाइल नंबर मिला। तो पश्चात गुमला के द्वारा जमा गवाहों को दिया गया और विकास बैठा को एनडीपीएस 75 का नोटिस देते हुए कंपनी मोबाइल किया गया। उसके पास से आप मेरे पास से खाली एक मोबाइल था और कुछ नहीं।
Where is the state?
This is the bill of the
For the council appearing on behalf of the petitioner, nobody appears on behalf of the state. The learned counsel for the petitioner has submitted that the petitioner is in custody since 12/11/2025, and it is alleged that from the joint possession of 3 persons, including the petitioner, the total 250 plus 8 is equal to 258 grams of brown sugar has been recovered. He submits that though all the 3 persons were moving together, but they were independently searched, and from one person 250 grams of brown sugar was recovered, and from the other person 8 grams of brown sugar was recovered, and so far as the petitioner is concerned, only one mobile was recovered. and therefore he submits that practically there is no recovery from the possession of the petitioner. He has also submitted that the petitioner has no criminal antecedent. He has referred to paragraph 12 of the bail application. The learned counsel 11. The learned counsel has also referred to the order dated 19th of March 2026 in BA number 335 of 2026, whereby the person from whom 8 grams of brown sugar is alleged to have been recovered has been enlarged on bail. Though the counsel for the state is absent, but a counter affidavit has been filed in the present case. Para 9. From paragraph 9 of the counter affidavit, it is apparent that the petitioner is not involved in any other case. After hearing the learned counsel for the petitioner and after going through the counter affidavit, and also the fact that individually from the petitioner only one mobile was recovered, and the co-accused, namely Vikas Kumar Baitha, has been enlarged on bail in BA number 335 of 2026 by the order dated 19th of March 2026. The petitioner decided to be enlarged on bail. This is the first state capture.
Sorry for interference.
अभी no interference, please don't. अभी सॉरी का टाइम नहीं आया क्योंकि इंटरफेयर हम करने नहीं देंगे. चलिए.
Item 28 PA 1589 of 2006.
Yes, please. Counsel for the petitioner seeks permission to withdraw this bail application, which is dismissed as reported.
Fine. Item 29 BA 2160 of 2026.
Persons were apprehended in the Bahubali transaction. It has been arranged that 22.05 grams of brown sugar were recovered from possession of this petitioner matters, and he is in custody since 1st of November 2025. He is having no criminal antecedents. Rather, I have been arrested from my shop. But that has not been shown. The independent witnesses were present over there, but their statement has not been recorded for us. In the present case, there is no independent witness only on the basis of in the presence of the police personnel for us, this FIR has been registered. In the FIR itself, it has been that from my position, 22.05 grams of brown sugar, mobile was recovered, and for that, I am custody since 1st of November 2020. Intermediate quantity. In this case, perhaps the charge sheet has been submitted. Cognizance has not been taken for the want of FSL.
Let the FSL report be called for from the concerned state. Communication. Next day 20 तारीख. FSL रिपोर्ट मंगा लेते हैं.
Yes.
आपका भी काम हो जाएगा. आप कम्युनिकेट करेंगे अथॉरिटी को. Counsel for the state is also directed to communicate this order to the concerned authority. वैसे यहीं से जाएगा order. ये FSL रांची होगा ना? FSL रांची है ना? पूरे झारखंड का FSL यहीं होता है ना?
Passover case item 2 BA 2248 of 2026.
This is an application for the offence is alleged under section 8C and 22 is for the NDPS Act, and under section 18C and 27 of the Drugs and Cosmetics Lord, there is no recovery from Lord, the person of the petitioner. The recovery of Lord, Orex cough syrup and Lord, the nitrogen balm tablets from Nadeem and Sufyan, who are not the petitioner, Lord. This petitioner, Lord, merely on the basis of professional statement, is languishing in jail since 16/1/2026. Lord, in this case, Lord, there is no private evidence available regarding Lord, the inventory, photographs, and sealing, which is required Lord under section 52, capital A, subsection 4 of the NDPS. When you find from the serial list,
पोजीशन तो बता रहा है कि आप ही से रिकवरी ऑर्डर में जैसा लग रहा है
ये तो हम सीरियल लिस्ट है इसको देखते हैं पेज 22.
Counsel for the petitioner submits that the petitioner has been falsely implicated in this case and there is no recovery from the possession of the petitioner. The counsel for the state is directed to seek instructions and file a contract. Specifically stating as to whether there is any recovery from the possession of the petitioner.
नदीम के पास
Call for along with the antecedent report, case diary 1 20 April.
Also case item 4, BA 2262 of 2026.
Under section 392 of the IPC, it is alleged that the whole miscreant went to the house of informant and looted 35,000 rupees and ornaments of 40,000. Because the petitioner is not named in the FIR, nor any incriminating has been recovered from the possession of the petitioner. Though the informant in the FIR, though the informant is claimed to identify the miscreant, no TIP was conducted to indicate.
How many
Only, yes, Lordship, that I have stated. Only on the basis of 2 antecedents I was remanded in this case, and apart from that, nothing is.
How many antecedents?
2 antecedents in which I have been
कहाँ है
granted.
बताइए?
Not I have stated, Lordship, that I have stated that apart from this case, 2 more cases, he has been enlarged on case. और सिर्फ इसमें सस्पिशन के अलावा जो उनका कंसेशन उसके अलावा कुछ भी नहीं होगा. In similar, the possession mobile has been recovered, who has already been granted. Rest 3 of the accused person and except 2 I managed, Lordship, they have been enlarged on case. बिल्कुल संसारी हूँ, पोजीशन माय नेम.
आप अपने एंटीसीडेंट के बारे में कहा
देखिए लॉर्डशिप दैट इज आई हैव नोटेड सॉरी
दूसरा कोर्ट में जाना है
नो
क्या बोलना है रिकवरी है इनके पास से टीआईपी नहीं मोबाइल किनका रिकवर हुआ इनके पास से
पास में टीआई बुलेट में इनका मोबाइल क्या
वो तो मोबाइल का टीआईपी हुआ होगा इनका थोड़ी टीआईपी हुआ मास्टरमाइंड
तो ऑर्डर से तो निकालो बोल रहे
ऑर्डर
एक चीज
हैं इस नेम द पिटिशन एज अ मास्टरमाइंड है पूरा हीरो कहीं
एक सबमिशन और जो मोबाइल रिकवर हुआ है वो जो चोरी ही नहीं हुआ और मोबाइल इसमें अगर आंसर टू 16 देखा जाए जिनसे मेरा नाम आया दिस बिलोंग्स टू दिस पिटिशनर that has come also. FIR में कहीं मोबाइल का है नहीं कि मोबाइल लूट हुआ.
और the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that the petitioner is neither named in the FIR nor there is any recovery. And the petition has not even been put under TIP. Custody कब से? The petitioner is in custody since 23/12/2025. He has also submitted that petitioner has 2 other criminal cases, and in both the cases he has been enlarged on bail. He has referred to the statements made in paragraph number 14 of the bail application. Counsel for the state has opposed the prayer and has submitted that, as per the confession statement of the co-accused, the petitioner is the mastermind in connection with the occurrence. To this, counsel for the petitioner has submitted that 2 of the co-accused persons, 3 co-accused persons have been enlarged on bail by coordinate bench of this court in BA number 5295 of 2025, Dilkush Ansari, by the order dated 21/6/22, and in BA number 5713 of 2022, Mubarak Ansari and Samir Ansari. तो इतना दिन से आप कहाँ पर?
मेरा कन्फेशन मिला, हम तो रिमांड होके इसमें आए, ये लोग तो थे भी नहीं.
Considering the fact that co-accused have been enlarged on bail and that the name of the petitioner has come in the confession statement of the co-accused and the petitioner is in custody since 23/12/2025, the petitioner is directed to bail.
Item 5, BA 2265 of 2026.
Yes, petitioner. Petitioner absent or repeated call by way of last indulgence, court is withdrawn. Next.
Also case item 6, BA 2272 of 2026.
कौन से डेट दिया है इस केस में, कौन से डेट दिया, कौन से डेट दिया है? Counsel for the petition submits that. Counsel for the petition seeks adjournment and submits that Mr. Ankit Apurva, the arguing counsel, is not available on account of his personal reasons. Post on 20 days.
Item 8, BA 2278 of 2026.
In this case, the police received the confidential information regarding gathering of the thieves for the purposes of stealing of the motorcycle. Initially, it was 3 motorcycles with 6 persons were apprehended. Thereafter, they confessed the name of 9 other persons. Now, my name has come and from my it is said that 1 motorcycle has been recovered. There is no theft report, nothing. No criminal antecedent also at paragraph 13, and the others have been granted regular bail.
आपके पास से रिकवरी हुआ?
At the instance that has come in the season.
उसका डॉक्यूमेंट्स आपके पास था?
Page 23 may be seen.
भाई रिकवरी ऑफ थेफ्ट आर्टिकल के लिए
what is for only the season may be seen. That is part of the page 23 for them. Page 23, the season is there.
Yes, this is concerning you?
Yes, Lord. Lord, I could find my name over there. It has been seized from the house of Sailesh Mato, but what is written here of Sunil Kumar Mato ke nisaan dekh. This is the only thing. But at the top, स्थान का विवरण जहाँ कहता है?
स्थान का विवरण. सैलेश महतो पिता से
स्वयं के घर के बाहर के आंगन से. Lord, it is from his house. और उसके ब्रैकेट में लिखते हैं सुनील कुमार महतो के निशान देंगे. This is the only thing, Lord. I have no antecedent, nothing, Lord. Others have been granted.
No antecedent.
No, ma'am. Para 13 I have disclosed. And annexure 2 and 2/1 Lord are the bail orders with respect to other courts. And I am in custody since 13/10/2025.
Where is the bail order of court?
Lord, annexure 2 Lord. Page 57, 58 Lord. And thereafter also Lord one further Lord by the court. Two was there, this is.
Or the learned counsel appearing on behalf of the petitioner, nobody appears on behalf of the state. The counsel for the petitioner submits that he is in custody since 13/10/2025 and has no criminal antecedent as stated in paragraph 13 of the bail application. He has referred to the season list and has submitted that the
Page 20.
सुनील कुमार
Mahto
के
निशानदेही
निशानदेही on the
at the instance of Lords.
of the petitioner. And I stated that the recovery of one motorcycle is from the house of Salish Mehto.
No.
Who accused him? Salish Mehto?
No, your Salish Mato's name is not there. The 15 persons who are named in the FIR.
From the house of Salish Mehto at his courtyard.
No.
And it has been mentioned that the motorcycle has been recovered, one stolen motorcycle has been recovered on the basis of disclosure of the petition. The learned counsel submits that for accused persons, namely Karan Goswami, Manoj Oraon, have been enlarged on bail in BA number 225 of 2026 and BA number 10975 of 2025, annexure 2 and 2/1. And the petitioner is in custody since 13/10/2025, having no criminal antecedent. He was also referred to on BA number 2123 of 2026, by which bail has been granted by the order dated 17/3/2026.
Even charge sheet submitted was cognizance is also being taken. 11/12.
Charge sheet has already been submitted.
Cognizance has been taken on 11/12/2025. Paragraph 59.
That's it. After hearing the learned counsel for the petitioner and considering the fact that number of co-accused have been enlarged on bail and petitioner having no criminal antecedents, the petitioner is admitted to be enlarged on bail. The learned court shall call for the antecedent report of the petitioner before enlarging the petitioner on bail. If any antecedent is found, the court shall not enlarge the petitioner. Communicate the
Item 9.
communicate state absent.
Item 9 DT.23.03.2026.
Yes, petitioner.
It is alleged that three unknown persons looted away 2,80,290 rupees from the informant.
How many antecedents do you have?
Petitioner has two criminal antecedents, madam. I have not stated criminal petitioner, madam. जिसे रिमांड हुआ है उसका हम जिक्र किए हैं। और दूसरे का नहीं।
The state is directed to file a counter affidavit along with criminal antecedents of the petitioner. Call for case diary from the concerned court. Most on 30 counter file
20.
13 तारीख।
Item 11 BA2308 of 2026.
But the case is under section 395 IPC and the charge has been framed under section 395 and 412 IPC. Petition. There is no incriminating article has been resolved from the position of the petitioner alert and there is no arms resolved from the position of the petitioner alert. Those two accused person have been targeted by the learned to in such alert. But the charge has been framed on alert 61/2025. But till then no witness has been examined. He is in dimension judicial custody since 25/2024 itself.
He is in custody since
25 no 20/5/2024.
बस
And he has no criminal action and
आपको क्या बोलूं? आपको क्या बोलूं?
रेड हैंड पकड़ा है तो प्लेस ऑफ ऑफेंस को पकड़ा है, गाड़ी की लाइट भी पकड़ा है और आदमी भाग गए लेकिन वो खदेड़ के पकड़ा।
ठीक है सुनिए।
He has been apprehended by the informant and has been taken to the police station.
heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has no criminal antecedent,
No criminal.
placed in custody since 20/2024, and the charge has been framed on 16/1/2025. The learned counsel for the state has opposed the prayer for bail and has submitted that the petitioner was apprehended on the spot. During the course of hearing, none of the counsel for the parties have pointed out that the bail application of the petitioner was rejected earlier in BA number 7952 of 2024 by order dated 10/12/2024. Considering the serious nature of allegation against the petitioner and the bail having been rejected on merits earlier, this court is not inclined to enlarge the petitioner on bail, hence dismissed. Call the release, please. बाकी है चलिए बहस करते समय previous rejection is the first sentence. You don't need to apologize. Apologize to your client. चलिए next. कोई बात नहीं. कहाँ? हम तो आराम से सुने. 2 बार आपसे पूछे कुछ और बोलना है और स्टेट को भी होश नहीं है. आप जरा देखिए स्टेट को होश नहीं है कि अर्लियर रिजेक्टेड है. पिटिशनर नहीं बोल रहा है कि अर्लियर रिजेक्टेड है. आई एम एब्सोल्युटली क्लूलेस. कोई बात. नेक्स्ट.
Item 12, DT.23.14 of 2026.
Yes, petitioner. Just a moment. Not named.
Not TIP mail.
Not TIP.
Confession of the Ramjit Ganjun Mailuk and Ramjit Ravi have been released on bail Mailuk. I have been next order. And Santosh Rama. Indian confession से मेरा नाम है. हमारे क्रिमिनल सिस्टम में 3 केस हैं हम लिखे हैं. 2020 में तक इसके बाद इस केस उनको रिमांड नहीं किया. जब रिलीज हो गया तब केस रिमांड किया गया. हम लोग 4/4/2025 से कस्टडी में है. रामजीत गिरी के अगेंस्ट में 27 केस
FIR पढ़िए सर.
हमारा नाम विनोद कुमार की तारीख 26 वर्ष 10 को मुझे चालू करना की रांची का निवासी हूँ. आज दिनांक 13/22 को सुबह 10:20 बजे ग्राम चारा स्थित अधिकारी ने अपना बयान अधिकारी के समक्ष बिना किसी दबाव पर डर के बयान दर्ज कराऊँ. मेरे पिताजी स्वर्गीय जगन्नाथ जी का 60 वर्ष के एक विवादी दिनांक 12/20 को समय करीब 11 बजे भैंस चराने को लिए चारा छोड़कर दुर्गा जंगल गए थे. इसी भी शाम को करीब 5 बजे ग्रामीणों से सूचना मिला कि आपके पिताजी छोड़कर दुर्गा जंगल में मिले हुए हैं. सूचना मिलने के समय वहाँ ग्राम शादी के प्रोग्राम में मजा हुआ था. सूचना मिलने पर वापस वहाँ आकर अन्य ग्रामीणों के साथ अपने ग्राम चारा के करीब 2 किलोमीटर दूरी पर छोटा दुर्गा जंगल में पहुँचे. देखा कि मेरे पिताजी के बल की अवस्था में गिरे हुए थे. तब उनकी शरीर के देखा कि मेरे पिताजी के कमर के ऊपर बाएं साइड में 3 उंगली लगने का जख्म तथा दाहिने साइड कमर के ऊपर भी जख्म का निशान है. नाम से आपको मनाकर अपने पिताजी के शव में घर लाए और उसकी सूचना चालू पुलिस की सूचना पाकर पुलिस आई और पिताजी के शव को अपने कब्जे में लेकर पोस्टमार्टम के लिए गए. कल दिनांक 12/2020 को मिलने की स्थिति में नहीं है. मैं आज दिनांक 13/2020 कर रहा हूँ. मेरा दावा है कि मेरे पिताजी को अल्लाह द्वारा जिंदगी मात्र हत्या की गई है. यही मेरा बयान है जिसमें मैं अपने समाज और पड़ोसियों को समझकर सही निकाह पाकर हस्ताक्षर करूँगा.
Counsel for the state is directed to file a counter-affidavit in this case, clearly stating the basis on which the petitioner has been made an accused in this case, along with the criminal antecedent of the petitioner. Call for case diary from the concerned court, communicate, post on 20th April. क्या basis है? Is important.
Item 13, DA.23.19 of 2026.
The prior item is section 96 and 820 of the
Read the
Corporate
FIR.
Act of
Read the FIR.
निवेदन का कहना है कि मैं रामू वर्मा उम्र 40 वर्ष पिता सेकंड सच जिला सेकंड दिनांक 14/10/2025 को हम सभी परिवार रात में खाना खाकर अपने कमरे में सोने चले गए। मेरी बेटी अर्चना कुमारी उम्र 15 वर्ष मेरी बूढ़ी माँ विवाह देवी के साथ चली दिनांक 15/10/2025 को समय करीब 4:30 बजे सुबह को मैं उठा तो देखा कि मेरे घर का दरवाजा खुला था। घर पर मेरी माँ विवाह देवी सोई हुई थी लेकिन मेरी बेटी घर पर नहीं थी। तब मैं अपनी माँ को उठाया और पूछा कि अर्चना कहाँ है। तब बताई कि मेरे साथ
What
सोई
is
थी।
the victim has been recovered?
Lord,
What is the statement of the victim?
Lordship, may I see the case diary of this case, Lordship?
Where is the
It's also case diary not been called for in this case.
आपके पास है?
नहीं मेरे पास भी नहीं है पर ये इम्प्यून ऑर्डर में आया Lordship। ये पेज 15 में काइंडली सी the last paragraph.
Yes.
Other witnesses of the reported case during their statement given before police as available in the case diary. Statement of victim has been recorded under section 183 of the witness, where she has stated her age as 15 years. She also stated during her statement that the accused had taken away from her house element of marriage and had established physical relationship. ये और इस एफआईआर में भी था कि लड़का और लड़की दोनों में बात होता था और ये लड़की साथ में गई है, वॉलंटरी गई है। फिर देन इसके पेरेंट्स जो है वो केस किए और prisoner has been arrested and the victim has been recovered from the
Age क्या बहुत?
Age 15 years around.
Petitioner 26 साल का है।
हाँ, petitioner 26
उसको तो मुक्ति होना चाहिए।
Case diary में भी call for
not required. DA number 2319 of 2026. Heard the learned counsel appearing on behalf of the petitioner. He has submitted that
case diary में
the petitioner has
verification
the counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and in fact, the victim had made a statement under section 183 BNSS that she was 15 years of age and the accused had taken her away from house under allurement of marriage and had also established a physical relationship. Considering the direct allegation against the petitioner and the victim being a minor, this court is not inclined to enlarge the petitioner on bail rejected.
For admission item 14, DA 9696 of 2025.
The main allegation against the accused petitioner is of the abduction. He has not been named in the FIR. His name has come in the confessional statement of the co-accused, and the confessional statement was taken by the police, which has no evidentiary value. In addition, my bail has been rejected on the ground that I have been identified in the TIB. And the addition, however, the person who was abducted, he was all throughout, he was blindfolded, and his name he never heard. In his statement, he has never taken his name, the petitioner's name. He was at home taking care of his ailing son-in-law, and just because he has got the antecedents, he has been implicated in this case.
So he has been identified also?
He has been identified by the person who was all along was blindfolded. This is the case. He is having a small child, he was at home and he was taking care of the ailing son-in-law. Just because he is having the criminal antecedent, he has been implicated in this case.
And that is why he has been identified also.
Identification again has been by
Identification का क्या validity होगा, कितना देखेंगे, very difficult. In the case where in a case of this nature, if a person is identified,
and been arrested on 8/6/2025. It is 9 months 15 days. He is in custody for almost 10 months now. And one of the co-accused has been granted bail. Just now I have got the information.
क्या बोलना है आपको?
पुलिस ने वो पकड़ी है एक कोई किसी के पास से 9 लाख रुपया रैंसम अमाउंट रिकवर
Not from his. Nothing has been recovered.
कहने पर कहाँ मिलेंगे ये लोग जाके पकड़िए
This money was recovered from the house of Ramesh Karmani.
Yes, he is the co-accused. Nothing has been recovered from his possession. No incriminating article.
For the learned counsel appearing on behalf of the parties, the learned counsel for the petition submits that the petitioner has been falsely implicated in this case. The person who had identified the petitioner remained blindfolded throughout, and therefore he could not have identified the petitioner in TIP. And therefore the TIP has no relevance in this case.
The FIR is against the unknown.
And the FIR is against the unknown. The learned counsel for the state has opposed a prayer for bail and has submitted that the limited amount of rupees the kidnapped person was later on released upon payment of rupees 9 lakhs, which was recovered from the house of the co-accused, namely Ramesh Karmani, and he has the victim has identified Ramesh Karmani as well as the petitioner in the TIP. After hearing the learned counsel for the parties and considering the serious nature of allegation and that the petitioner has also been identified in TIP, this court is not inclined to enlarge the petition on bail.
At this stage.
It's always at this stage. You can file it every day.
Item 15 PA 10915 of 2025.
It is a case of Bukati Loshan. In this case, Loshan has stated that out of 17 cases against this petitioner, 12 cases have been admitted that I have stated previously. I am not able to find all the judgments as because some of the cases are of the year 2006, 2009. I have procured 3 judgments in which he has been acquitted, and there are 2 status reports in which one FRT has been submitted and there's 2 cases has been acquitted. The status reports. We have applied for the certified copy of some of the judgments, the registry of Jharkhand, as well as
For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that although it is alleged that the petitioner is alleged it has involvement in 17 cases, but as per his knowledge, he has been acquitted in 12 cases.
yes, sir.
The counsel for the state has opposed the prayer and has submitted that the name of the petitioner has come in the confession statement of the co-accused leading to recovery. The status report reveals that as on 11/3/2026, all witnesses except one were already examined. Considering the fact that the trial is at back end, this court is not inclined to enlarge the petition on bail. Please report.
Item 19 PA 11514 of 2025.
FIR against unknown.
FIR against him. Subsequently, you are also stated that the persons who were arrested they gave their confessional statement on the basis of which it is stated that this small child was taken away by them and sold to the petitioner for ₹90,000. And the small child, your lordship, it is alleged that he was recovered from the possession of this petitioner.
Sold to the petitioner.
Sold.
Recovered from your possession.
Yes, your lordship, but
How does the child come to your possession? Are you a relative?
your lordship, my child has been recovered and taken away by them. My small child has been taken away by them. And save and accept this allegation, there is no other allegation.
Your child has been taken away.
Taken away by them.
When was your child born?
Born, your lordship, that I have not
Document
stated.
detail. Child birth ka document detail.
Yes, your lordship, please see only one thing.
If you have, if that is your case, Mr. Tiwari, it's a very serious matter.
Very serious.
Therefore, you file some affidavit showing that on what date your child was born, right? In which hospital. And birth certificate must also have been issued by now of your child.
Your lordship, the only
You annex those documents.
only thing, if the child has been recovered from my possession, then a seizure list should have been prepared. There is no seizure list of any manner whatsoever. What they say, the police says, the child belonging to the father recovered from me, given it to him. This is the allegation, your Honor.
The learned counsel for the petitioner has submitted that the child who was born to the petitioner has been taken away by alleging that the petitioner had bought the child upon payment of ₹90,000. Counsel for the petitioner seeks adjournment to file an affidavit to show the documents in connection with the birth of child of the petitioner along with the birth certificate of the child. How much time do you need?
2 weeks.
Post on 20th April. 2 हफ्ता का टाइम. The counter affidavit, the supplementary affidavit we filed by 7th April. Counter if any by 20th April. Post on 26th.
Counter with respect to the statement given that
ये अभी जो बोले ना कि इनको जन्म हुआ था तो बर्थ सर्टिफिकेट होगा कोई प्रूफ होगा ऐसे कैसे बोलेंगे कि जन्म हुआ 22nd April.
Item 20, DA.23.03.2026 of 2025.
Was confirmed and approval that to my daughter this specific plan, but CDR has been received today itself. I know.
How much time do you need?
1 day, 1 month.
At the request of the council for the state, the matter is directed to be posted on Tuesday in the supplementary process. In the meantime, the supplementary affidavit should be filed by Friday. Okay? Friday तक? फिर Friday छुट्टी by Monday. By Monday फाइल करेंगे. Tuesday छुट्टी है क्या? छुट्टी है Monday को आप फाइल कर दीजिए. Wednesday को. ठीक है? Wednesday. अपने पास मत रखिएगा. फाइल कर दीजिएगा. हम फाइल देख कर आते हैं. उसमें सप्लीमेंट्री एफिडेविट नहीं रहेगा तो हम देखेंगे ही नहीं फाइल.
Item 31, DA.11.93.5 of 2025.
one week time on file counter ready हो जाए तो
किस डायरी वाला
ये आ गया
ये इंस्पेक्टिव डेट वाली
अब काउंटर का जरूरत नहीं है. क्या समझ उनके पास आ गया
ये
इंस्ट्रक्शन.
ले अगले केवल डायरी होना
कोई बात नहीं. डायरी मंगा दिया. ऑर्डर दे दिया. फाइल करना चाहते हैं करना. Council for the state submits that he has received instructions to file counter affidavit, which will be filed by next Monday. पोस्ट ऑन रजिस्टर। यहाँ पर भी मतलब कोर्ट मास्टर को भी दे दीजिएगा अगर फाइलिंग होता है ना।
Item 23, DA.23.07 of 2025.
We will not name the waiver. IR was against one Kunal.
Read the FIR.
It is page 12. आज बिना कितना हो नापी होना पुलिस और अधिकारी के समक्ष बिना भय दबाव लालच की अपनी सुरक्षा से ज्ञान अंकित करता हूँ कि दिनांक 7/9/25 को अपने किराए के घर में घटना टालने से क्योंकि मेरे पिता के द्वारा यहाँ रहकर उषा मासू में नया घर का निर्माण कराया जा रहा था। आज दिनांक 7/9/25 को समय 19:30 बजे जानकारी मिली कि मेरे पिता रवि कुमार एवं अन्य व्यक्ति को घटना टालने के मकान में कुछ अज्ञात अपराधी द्वारा 6-7 राउंड फायरिंग की गई, जिसमें वहीं बैठे मेरे पिता रवि कुमार की मृत्यु हो गई तथा साथ में बैठे राजवल्लभ लोग घायल हो गए हैं, जिसे इलाज हेतु रांची भेजा गया है। इस सूचना पर मैं अपने मेरे भाई रवि कुमार के साथ तत्काल रिम्स पहुंचा तो पाया कि मेरे पिता रवि कुमार इमरजेंसी वार्ड में स्टेशन पर अवस्था में पड़े। आसपास से पता चला कि आज दिनांक 7/25 को संध्या करीब 6 बजे घटना का मृत्यु पत्नी लोहा उत्तरपुर के घर में राजवल्लभ शराब पी रहे थे कि इसी बीच मेरे पिता रवि कुमार वहाँ पहुँच गए और दोनों साथ में शराब पीने लगे। इसी बीच 2 व्यक्ति आए और राजवल्लभ को कौन है पूछते हुए अचानक अपराधकर्मी गोली चलाने लगे, जिससे मेरे पिता रवि कुमार गोली लगने से जख्मी हो गए और उनका मृत्यु हो गया। उसके बाद राजवल्लभ को अपराधी का पीछा करने लगे, तब अपराधकर्मी पीछे घूमकर निशाना बनाते हुए राजवल्लभ को गोली चलाया, जिससे गोली उनके मुंह में के पास आकर लगा और वे पूरी तरह से जख्मी हो गए। जब मैंने इस घटना के बारे में घायल राजवल्लभ लोग से पूछा तो उनके द्वारा बताया गया कि किसी बात को लेकर लाल कुमार पिता सज्जन सर से राकेश के साथ पुरानी दुश्मनी एवं बात को लेकर पहले भी कई बार जान मारने की धमकी दिया गया था। यह घटना लाल कुमार द्वारा पुरानी दुश्मनी होने के कारण इनका हत्या कराने के लिए अपराधकर्मी को सुपारी देकर इनको गोली चलवाया, परंतु अपराधकर्मी के द्वारा गोली चलाया जिससे मेरे पिता रवि कुमार को गोली लगा और उनकी मृत्यु गोली लगने से हो गया। मुझे पूर्ण विश्वास है कि कुमार अपने अन्य साथी के साथ योजना बनाकर गोली चलवाया, जिससे मेरे पिता रवि कुमार का हत्या कर दिया गया तथा राजवल्लभ को जख्मी कर दिया गया। इसमें क्या है? It's not known for date at the base time date on the offense. There is no recovery from the person and possession of this petitioner, and there is no overt act against the petitioner. And same and similar footing, one the co-accused has been granted bail by the in regard of same impediment. Okay, only confession statement is there, except this nothing. So far concerned regarding criminal antecedent matter. Criminal antecedent has mentioned in the case diary, my lord, at para 164, my lord.
174.
Yes.
2 cases.
2 cases. One in which in one case he has acquitted and other he acquitted, which is the case of 414 of the IPC, and other case is on bail matter. Status report I have taken by.
क्या बोला?
नोटिस में यही बोलना है कि डेट ऑफ ऑफेंस में
क्या मटेरियल है?
एक्सीडेंट है कि सीटीआर है जो कि दैट इज के
काफी बार बात की।
जी
इसके अलावा तो कुछ नहीं।
कन्फेशनल स्टेटमेंट में एक दूसरे का नाम लिया गया है, विटनेसेस भी सपोर्ट किया हुआ है।
क्या विटनेस को आई विटनेस है?
आई विटनेसेस there is no eye witnesses until also there is a causes of death is due to firearm also.
फायरआर्म भी तो रिकवर नहीं की इनके पास से। कस्टडी कब से आपको?
No.
No. 9/1/26 चार्जशीट हो गया आपको? कैसे बोल रहे हैं?
सेशन पुलिस पेपर रिसीव
कर रहे हैं।
Chargeshit has been submitted.
Heard the learned counsel is appealing on behalf of the parties. The learned counsel for the petitioner submits that the case is against unknown and
8/9/25 से
the petitioner is in custody since 8/9/2025. He submits that neither the petitioner is named in the FIR nor there is any recovery from the possession of the petitioner. He has further submitted that though the petitioner has two criminal antecedents, but the one is under section 414/34 IPC and the other is under the Arms Act, and he has been acquitted in the case registered under 414/34 IPC, and so far as the Arms Act is concerned, he is already on bail. He has also submitted that the co-accused, namely Bablu Yadav, has been enlarged on bail by the order dated 27/2/2026. Counsel for the state has submitted that as per the counter affidavit, the petitioner was talking with the co-accused persons, as has come in the all detailed report within bracket C. After hearing the learned counsel for the parties, and considering the fact that the petitioner is neither named in the FIR nor there is any recovery from the petitioner, and the co-accused has been enlarged on bail, the petitioner is admitted to the trial.
From date is item 1, second appeal 423 of 2003.
Pray for each time just as Secretary is engaged in this matter and he is out of station for personal reason. That's why he is praying for time in this matter. The last appeal notices was issued. They have appeared through substituted here.
Substitution has been allowed.
It was allowed and notices were issued. They are
Substitution allowed करके हम notice नहीं करते. Substitution के पहले notice.
notices were issued.
By which order?
Allowed?
By which order? By which order?
January order, not January 26.
That is order number 7, dated 27/1/2026.
27/1 or 21/1?
Yes.
27/1.
21st of January. Order number 7.
कोई आईए पेंडिंग है इसमें?
एक IED
कौन सा आईए? किसका सब्स्टिट्यूशन?
नहीं सब्स्टिट्यूशन का नहीं, वो कुछ डॉक्यूमेंट्स रिकॉर्ड पे लाने के लिए
एक एडिशनल एविडेंस के लिए है जो हम लोग लिस्ट से देखे उसका कॉपी हम लोग को नहीं मिला। एक 5469/22 है सब्स्टिट्यूशन ऑफ रिस्पॉन्डर नंबर 1 के लिए
5469
नहीं, वो तो
5469 and 5468.
हाँ दोनों, ये दोनों पेंडिंग है। खाली 5732 तो हम लोग फाइल किए थे।
वो से पहला
वो
नहीं, आपका एक IA नंबर 12014
वो भी डिस्पोजल हो गया है।
वो डिस्पोजल
नहीं, ये वाला पेंडिंग है।
ये दोनों
5469 and 5468 ये दोनों पेंडिंग है।
सब्स्टिट्यूशन
additional 10 का 287
2874 of
26.
26 additional units. इनका नोटिस कंप्लीट है, अपीयर हो गया सब। Respondent number 1. इनका आईडी अलाउ कर देते हैं।
देख लेंगे।
अब क्या
ये वो नहीं, हम खाली एक बार बता रहे जो 272 डेज का डिले है वो इनके ऊपर ओनर उसके ऊपर उसका सफिशिएंट रीजन है कि
2003 से अब क्या देख लेंगे, हम तो ऑर्डर कर रहे हैं 2003 से पेंडिंग है यहाँ पे क्या ऐसे नंबर 423 of 2003 IA number 5469 of 2022 and IA number 5468 of 2022. The learned counsel for the appellant has submitted that IA number 5469 has been filed for substitution of respondent number 1 who is said to have expired on 17/9/21 and the proposed one of the proposed legal year of respondent number 1, that is respondent number 1 within bracket 1 had also expired. And the other legal years of respondent number 1 are the proposed legal years of respondent number 1 within bracket 1. There is a petition seeking condonation of delay of 272 days through IA number 5468 of 2022. Notices were issued and the notice has been duly served. Counsel for this respondents has opposed the prayer, however nobody has appeared on behalf of the legal heirs and successors of you are representing the legal heirs and successors of respondent number 1 is present. Who are the proposed legal heirs as mentioned in IA number 5469 of 2022 being respondent number 1 within bracket Roman 2, 1 within bracket Roman 3 and 1 within bracket 1 within bracket Roman 2 to 1 within bracket Roman 5. Any objection? The learned counsel has no objection so far as the prayer for substitution is concerned. After hearing the learned counsel for the parties and upon going through the interrogatory application and being satisfied with the cause shown, IA number 5469 seeking condonation of delay and setting aside abatement and IA number 5469 of 2022 seeking substitution is hereby allowed. Counsel for the appellant is directed to delete the name of respondent number 1 from the first title and insert the name of the proposed legal heirs and successors who are respondent number 1 within bracket Roman 2 to 1 within bracket Roman 5 in reading. आप कर लेंगे during the process. 1 within bracket Roman 1 का नाम नहीं डालना है क्योंकि उनका डेथ
2 और 5.
अब आइए 2 to 5. अब कौन सा आइए एडिशनल एविडेंस, क्या एडिशनल एविडेंस आप डालना है?
16(3) का पिटीशन इन लोगों के बीच में चला था, वो अप टू दिस ऑनरेबल कोर्ट एलपीए तक वो डिसाइड हुआ, वही सब सारे ऑर्डर्स को लगाया गया.
16(3) का पिटीशन
तो वो
प्रीएम्पशन पिटीशन हुआ था, तो बीच में प्रीएम्पशन का केस चला था, एससी बोर्ड ऑफ रेवेन्यू रिट पीए ऑर्डर, वही सब ऑर्डर्स को केवल लगाया गया इसमें, उसको लाया गया।
देखिए एडिशनल एविडेंस में कभी भी फोटोकॉपी नहीं चलता, सेकेंड अपील है सिविल लिटिगेशन।
एडिशनल एविडेंस
आप सेल भी तो लगाएंगे, तो सेल भी लगाएंगे।
सेल्डिट का चर्चा उसमें सारे ऑर्डर्स में है, उसी का केवल वो सब
आपको बात समझ नहीं आ रही है। सिविल लिटिगेशन में फोटोकॉपी नहीं चलता, आप इसका रिप्लाई तो फाइल कर दीजिए।
बोले हैं कि कॉपी नहीं दिया, आई एम ऑलरेडी टोल्ड हिम कि कॉपी दे।
अभी हम कॉपी इन द कोर्स ऑफ द डे हम दे रहे हैं।
कौन है आपका ये गोइंका?
Yes, ma'am.
It has been served upon you. And your corresponding number?
The respondent number 325.
KIA number 2874 of 2026. The learned counsel for the respondent number 225. 325. 325. Some is that he has not been served with a copy of the interlocutory application seeking to adduce additional evidence. Counsel for the petitioner undertakes to provide a copy to him during the course of the day and file the receipt by tomorrow. The counsel representing the legal years of respondent number 1 has already received the copy. The counsel for the respondents pray for and are granted how much time do you need? 3 weeks time. To file response to this idea. Prays for and is granted time till 13th of April to file a counter affidavit to the interlocutory application seeking to adduce additional evidence. Rejoinder if any by 20th April. Post this case for final disposal on 22nd April. The parties to prepare synopsis, list of dates, and also furnish the copies of the judgment which is to rely upon.
Orders will be fed
And written notes of arguments.
Item 30, first appeal 1/6 of 2022.
ये इस लिस्ट में कैसे है? इस लिस्ट में क्यों? ये पता है? ऑलरेडी डिस्कस फॉर डिफॉल्ट केसेस के लिए एक बार बोलेंगे, कितना बार बोलेंगे?
Orders item 31, first appeal 326 of 2023.
Yes, ma'am. FA number 326 of 2023. By the order dated 17/3/2025, notices were issued upon the respond number 128 in spite of repeated issuance of notice upon respond number 225 and responding number 628 and 10. The notice could not be served as per the office note. The addressee has either left or not found. Substituted service owner. Counsel for the petitioner prays for 1 week time to take steps for substituted service owner. Post on 1st April.
Item 32, 1st April 19 of 2024.
April number 19 of 2024. As per the office note, notice upon responding number 3, 4, 5 and 6 has been either personally served or through their close relative. Accordingly, the notice is accepted as validly served. Record address. Record has come.
जी.
You are for the respondent.
Respondent 1, 2, 7 and 8.
Also for the applicant and respond number 1, 2, 7 and 8 are present. The suit was dismissed. You are the plaintiff. Read the appeal order. What are the issues framed? Straight come to the issues. कब करना बताइए. रिकॉर्ड आ गया ना इसका? Yes, when do you want to do it? When do you want to do it? Sorry? Who is your senior? You will do it or somebody else will do it?
My senior is coming.
Your senior is coming. You are, for what are you standing? When do you want to do it?
Can you please give the next date?
कब करेंगे आप बताइए?
Actually, it's a problem that minimum of appeal has not been served upon us. Even notice page is there.
Counsel for the applicant is directed to serve a copy of the memo of appeal along with its enclosure to the learned counsel appearing on behalf of the aforesaid respondents by day after tomorrow and file a receipt of the same. The final disposal के लिए हमें कितनी cases रखते हैं? अगर हम लोग wait list में है cases final disposal के लिए. Post this case में final disposal and cost of appeal. Yes, madam, is that okay? First April, with the consent of the parties.
Item 33, first April 31 of 2025 along with item 34.
Also in serial number 34, there is an IA for combination of delay.
This is serial number 33.
Look at that, 33.
First I should take 34. First I should take 34.
There is an IA.
IA number
IA number 228.
2282. Medium Jan. Both the cases has been filed by the same person.
Yes.
Why?
One was for the cancellation of said deed that I have filed before the lower court in which it was decreed in favor of the defendants. And second was filed by the defendant for recovery of possession.
So both against both the cases you have two separate appeals.
Incident 31 it has
You have appeared in this case?
Yes, but in the second case, by mistake was the Wakalatnama is. So if 1 week time is not able to reply, Wakalatnama in the second.
Second case on behalf of all the respondents.
एक आदमी तो मामला जबरदस्ती Proforma, except for the proforma, the contesting.
प्रोफॉर्मा की तरफ से आप नहीं करेंगे कौन करेंगे? करेंगे? सॉरी?
उन्हीं के बेटे
हैं ना तो आप कर देंगे ना? I will record it then.
But 2 weeks.
Mrs. Elish accepts notice on behalf of respondent number 1 and 2. In the interlocutory application seeking confirmation of delay through IA number 2282 of 2025 and also in the first appeal, and undertakes to file Wakalatnama within 1 week. Within 1 week. Counsel for the appellant has submitted that so far as the proforma respondent number 3 and 4 are concerned, they are sons of the appellant, and he undertakes to file Wakalatnama on their behalf within a period of 2 weeks. Record आ गया इसका? Record?
First.
Let the records of the case we also called for from the concerned court upon deposit of special messenger cost by the appellant to be solved to be deposited within a period of 1 week. ये है FA number 32 of 2025. Okay. The records of the corrected appeal being FA number 31 of 2025 has already been received. And the appearance is complete. इसमें भी कोई delay वगैरह है? इसका
पहला में हमने नहीं वही शर्त था कि जल्दी
कब करना है ये बताइए। आप तो वकालतनामा फाइल कर दीजिए। करना कब है? डेट बताइए। आज 23rd है। 6 अप्रैल तक आप फाइल कर देंगे, ठीक है? करना कब? उसके बाद तो 7 तारीख आता है, कर लेंगे। इसलिए डेट आपकी सहमति से पूछ रहे हैं। 1st, 2nd, 3rd तो ये बताइए 22nd
जी
with the consent of the learned counsel for the parties post this case for final disposal on 22nd of April. The parties to submit short synopsis of their arguments and also the judgments which is to be live prior to the next date.
Item 35, first of is 77 of 2025.
Your Worship, respondent number 2 to notice served in reply to address not found.
We are appearing for respondent number
2. As per the office note, the respondent number 2 could not be served as he was not residing at the given address. अब क्या करना है?
Personal notice was
Personal notice मतलब
ठीक है, हम फ्रेश नोटिस कर देते हैं, आप नया एड्रेस पे टेक करते हैं।
also for the applicant days for 2 weeks time to take fresh steps upon respondent number 1 to respondent number 2 at his present and correct address, or to file an appropriate petition seeking substituted service. दोनों में से कुछ करिए।
हम नोटिस फ्रेश नोटिस कर देते हैं।
अच्छा, वो substituted वाला में through speed post. Post on 29th April, office to tax speed post. कहाँ के रहने वाले हैं respondent?
हजारीबाग के यहाँ पे एड्रेस चेंज हो गया उनका, हम पता किए हैं वो दूसरी जगह पे।
Item 36, first appeal 103 of 2025.
Yes.
My lord, as per office note, notice one is from correspondent number 5 to 26. Respondent number 5 to 7 appeared, and not respondent number 7, 11 and 13 does not tally with her name given in demo. Tracing report of respondent 5 to 17, 19 to 23, 25 and 26 delivered. Undelivered speed post and load respondent 18 and 24. 18
and 24. 18 was out of station. 24 is insufficient address.
Yes.
दोनों सगी बहन हैं। 23 कौन है? 23 की तरफ से 23 की तरफ से कौन है? Nobody. 5 to 12. FA number 103 of 2025. The learned counsel for the appellant has submitted that notice upon respond number 5 to 17, 19 to 23 and 25 and 26 through speed post has been delivered, but respondent number 8 was said to be out of address, and so far as respondent number 24 is concerned, the same could not be served on account of insufficient address. Counsel for the appellant is directed to take press steps for service of notice upon respondent number 18 through the concerned police station, for which requisites be filed within a period of 1 week. So far as respondent number 24 is concerned, the appellant is directed to take press steps for service of notice at his present and correct address, or to file an appropriate petition seeking a substituted service of notice. Okay? The present and correct address में एक बार try कर लीजिए. Substituted service मत कीजिए. For which requisites will file within 2 weeks. Within 2 weeks through speed post.
मेमो कॉपी में भी डायरेक्ट सर
आप लोग आपस में बातचीत नहीं करते हैं. Office to track speed post delivery post on 29th April.
Item 37, first of April 230 of 2025.
अभी इसमें नोटिस नहीं हुआ है. How many days delay? Who is for the state? कहाँ है आप? आइए. Land acquisition है. IA number 12146 of 2024. In FA number 230 of 2025. Counsel for the appellant submits that the petition has been filed for condonation of delay of 118 days in filing the appeal. Nobody appears on behalf of the state, nor any counter affidavit has been filed to the executory application seeking condonation of delay. The learned counsel for the appellant has referred to paragraph 589 of the intermediary application and has submitted that the matter relates to acquisition of land. After आप state हैं, सरकार आप हैं. कोई बात नहीं. After hearing the learned counsel for the appellant and being satisfied with the caution, the interlocutory application seeking delay in filing the appeal is hereby condoned. Admit. Call for records from the concerned court. FA 1 out of the same proceeding. Common order की common procedure?
Pronouncement of judgment and demand.
The learned counsel for the appellant has submitted that the records have already been called for in FA number 1 of 2026. It is fixed on 26/3/2026. Close this case on 26/3/2026 and tag it along with FA number 1 of 2026. Since the counsel for the state is absent, let a copy of this order be forwarded to the Office of Learned Advocate Delhi to ensure appearance of the concerned counsel. आइए अलाउ हो गया रिकॉर्ड उसमें आ गया है
इसलिए कि ऑर्डर हुआ था 6/2/2026 को।
क्या मैटर है
इनहांसमेंट ऑफ डिमांड
आप इनहांसमेंट के लिए आए हैं फाइनल डिस्पोजल में वो फाइनल डिस्पोजल में है वो फाइनल डिस्पोजल में है
हाँ हियरिंग में 1/2026 में एडमिट हुआ था 6/2/2026 को और डेट पड़ा है 26/3/2026
और फाइनल डिस्पोजल कर आपको नहीं सुनवाई करना है
नहीं
सुनवाई करने के लिए तैयार लिस्टिंग हम लोग कर देंगे उसका आप चिंता मत करिए
Item 38, first appeal 231 of 2025.
नहीं सुनवाई करना है तो 10 साल तक का उपाय कर देते हैं तैयार होइए
इसमें आइए 11749 24 से 13 दिन का डिले
11749 आपने कुछ बोलना है आपको लैंड एक्विजिशन में फर्स्ट अपील में 113 डेज का दीजिए सेम ऑर्डर कर दीजिए या सेम ऑर्डर नहीं होगा
इसमें इसका कॉमन जजमेंट है एप्रिल 34/2025 में एप्रिल नंबर 34/2025
एप्रिल 34/2025
इसमें एडमिट हुआ है वो कॉर्पोरेशन
लगा कब
13/11/2025 लगा हुआ 1/4/26
IA number 11749 of 2024. Learned counsel for the parties are present. The interlocutory application has been filed seeking condonation of delay of 113 days. The counsel for the appellant has referred to paragraph 5 to 9 of the interlocutory application and has submitted that the matter arises out of land acquisition and if the delay is not condoned, he would suffer irreparable loss in entity. The learned counsel for the state has been serious objection so far as prayer for condonation of delay is concerned. After hearing the counsel for the parties and being satisfied with the cause shown, IA number 11749 of 24, seeking condonation of delay is hereby allowed. Admit. Counsel for the appellant has submitted that arising out of the same proceeding, FA number 34 of 2025 has been admitted, in which the records have been already called for from the concerned court, and the next date fixed in the matter is 1/2/2026. Tag this case in view of the future submissions. Tag this case along with FA number 34 of 2025 and post for final disposal on 1/1/2026.
Item 39, first appeal 232 of 2025.
IA number? 113 days. Yes, what do you have to say for condonation of delay? It's land acquisition proceeding. Same order करते हैं? Same order करते हैं. जिसका connected अपील बताइए.
34 से इसके जस्ट पहले
Same to same order. 34 में ना? Same order. इसका connected अपील है FA 34 of 2025. इसका next date है 1/4/2026. इससे connected कोई और अपील भी है क्या?
अभी ऑर्डर
कहाँ है? क्योंकि एक तब रेडी नहीं होगा तो क्या करेंगे? अभी होगा टेका? कल लगा हुआ है?
Date of the report is attached to first appeal.
ठीक है, थोड़ा एक लिस्ट देंगे आप, है ना, इसका जरा स्टेटस देख लीजिएगा, सारा 1 तारीख को कम से कम मैच्योर हो जाना चाहिए, रिकॉर्ड उसमें आ ही गया।
Item 40, first appeal 100 of 2026.
Yes, please.
Notice on 18th of February granting 1 week time to file requisites. After 3 days, thereafter vacation on 12th we could file the requisites in person.
Okay. FA number 100 of 2026. As per the office note, the notices have been filed after lapse of the time granted by this court. Counsel for the applicant has submitted that there has been a lapse of 3 days, and due to 5 days, due to inadvertence, the notices could not be filed in terms of order dated 18/2/2026. Considering the submissions, the notices filed in terms of order dated, notices filed pursuant to order dated 18/2/2026, though belatedly, is directed to be issued by the office. Post this case on 29th April, awaiting registry. Total limitation to appellant है काम appeal नहीं हो रहे. Nobody appeals on behalf of the appellant. Post this case on 29th April.
Item 39. For admission, item 41, the rupees 1839 of 2014.
Your Lordship, in the last order, Your Lordship, Ladyship, order 17, Your Lordship. As per the last order, Your Ladyship, the matter was referred to Shalsa, however, it was never listed Your Ladyship. And as per the matter listed.
Never listed means?
It was in the Jharkhand mediation initiated. My lord, it has
Some more time is required.
Your Ladyship, I have sought instruction from my client, Your Ladyship. The parties ready to compromise.
Have compromised.
mediation, as far as my information is concerned, they are offering very bigger amount, therefore my client has refused to.
It has failed. Mediation has failed.
Your Ladyship, in that case, Your Ladyship, my senior shall assist in this matter.
So should I go to his chamber?
No, Your Ladyship, the matter is for tomorrow person.
You want time? You are for the workman?
No, I am for the.
You are for the workman.
This is for the.
We can't grant you time in such a way. 2014, we will not grant you time. Who is your senior?
Miss Sandhanash provides Your Ladyship.
So?
I'll have to seek instructions, Your Ladyship.
You don't need to seek instructions in legal matter. You have filed wakalatnama, the records are here. What instructions? It will be decided on the basis of the records, no? There is no need of any instructions. You have filed your case, consulted your advocate, consulted your litigant, and then filed your case, right? It has been held that you are not a workman. It has been held that you are not a workman. And termination has been set aside. So you must have pleaded that he is a workman.
Yes, my lord. He was workman and under the Southern establishment, it has been decided, my lord, in my favor. They were a director to reinstate with put back wages. They have never reinstated me. And thereafter, my lord, they have put this.
I IA
Are you?
I give for issuance of direction for this one being on record is income tax return for the period of 2010 till date, because we came to know under the knowledge that he's working. So with respect to the back wages claim, since he's working in other companies, we came to know HR sources. So this
Where is that IA?
IA number 1794. So if he's working and paying the income tax, which will be reflected, then the question of back wages will be.
You file your income tax.
No, I will file the reply because this matter has gone for mediation. Therefore,
You file
since it
your
has
how
ended
many,
in the
how many days do you need to file your income tax?
within a week. Within a week. Whatever be the
Because an affidavit was filed which was later on withdrawn, he claimed that I was not working. But since Lord, this is a company and all the HR are connected, we came to know that he was working in one of the multinational companies.
What is the name of the company?
Lord, we have given he has taken the agency of one company as a insurance
I
agent.
mentioned in para 5 of my IA, Allied Insurance Company and one Star Health and Allied. His name is Star Health and Allied Insurance.
I will bring on record of everything.
And he's also having
one medical mediation, therefore I
he's also having one medical shop. So it must be reflected in his income tax return.
Which is statements of account. So the statement of account होता है ना?
Yes, I will certain.
And return also.
Then Bharat, I'm just making because I will ask him to bring out these documents. Give him one more week time. Within after in 2 weeks time we are fine.
IA number 1794 of 2025. The learned counsel for the petitioner has submitted that petitioner has been the respondent has been restated with full back notice. And as per the interlocutory application, the workman was duly employed, and therefore a petition has been filed asking the respondent to file his income tax details for the period from 2010 till date. Counsel for the respondent prays for time to file a counter affidavit to the interlocutory application and has undertaken to produce the income tax returns.
उसमें केवल ई फाइलिंग कर दिया जाए सब्जेक्ट
लिखिएगा ना कि फाइल नहीं करते.
हाँ
लिखिएगा ना भाई. Income tax returns for the period from 2010 till today.
Okay.
Just a moment. The affidavit should be filed by 7th April. Rejoinder if any by 13th. Post on 15th. Interim order passed earlier shall continue till 15th of April.
Article 42, WPA 3755 of 2025.
Who's for the petition?
This is an award in favor of the petitioner. That award page number 44 would be relevant. Page 44. Fees are directed to pay compensation of rupees 1 lakh to the workman within 90 days from the date of declaration. This has also not been paid, Your Lordship, and Your Lordship, we have filed for enhancement of the award, Your Lordship, and for the payment of
Enhancement of
one of the payrolls.
What enhancement rights?
Worship, our main prayer is for direction upon the respondent. We have filed that it is the nature of mandamus for payment of the wage out.
Mandamus?
Wages. Payment of the wages.
You read your prayers.
Well, page 3. For issuance of an appropriate rate, particularly a rate in the nature of mandamus commanding for the respondent to immediately will pay the wages to the petitioner outstanding dues from 12/8/2019 till 25/2/2025. That is the date of pronouncement of the order. As well as other benefits also. That has not been paid to the petitioner.
Mandamus का भी थोड़ी होगा. Mandamus कैसे होगा सर? What is a mandamus?
There is written outstanding dues as far as this petition is concerned. The last petition.
There was a closure. कुछ है नहीं application. You did not even claim any back wages.
Which we claim for back wages. Back wages we have claimed.
Back wages नहीं होगा ना. यहाँ पे आप मांग रहे हैं 2019 से लेकर 25 तक का back wages. ये तो mandamus यहाँ से नहीं हो सकता. Your this prayer is misconceived. How do you seek a mandamus from here?
As far as this award is concerned, you see 1 lakh rupees has been directed to me. That has also not been made to this petitioner.
You go and execute the award. Execution of the award. यहाँ से क्या ये executing code?
Section 25 है फिर बच्चे. That has also not been followed in this case.
इसीलिए तो compensation दे रहे हैं आपको. और क्या चीज़ का compensation?
Paragraph 21 and 22 of the pending question. Paragraph 20, 21 and 22, page 43. Page 20. From the above facts which is available on record, I find and hold that applicant is a worker of OP who has been duly discharged from his service as per MW1, paragraph 16 during the constitution, and the OP is ready to take back in the original position as per paragraph 10 of MW1 MD. Therefore, it is clear that the applicant who is permanent worker of OP is orally terminated without giving any notice or holding any inquiry and also without complying the provisions of section 25C of the ITA Act. Considering the case of both the parties and discussing the material record, I rely with the submission of the learned counsel for the applicant and find and rule that applicant is entitled for compensation of
rupees 1 lakh as he's fighting the case from year 2019, and OP has not given any letter to join his job only. They are saying that they are ready to take back to applicant in his original position. And also the applicant is not claiming the relief from back prison. The applicant is also entitled for his statement as the applicant prayed for relief, and the statement of number 1 and 2 are attended. Thus OP is entitled to pay. This 25C compliance is also not given in the relation.
That is their compensation.
But the amount is a very big amount. You mentioned 1 lakh rupees have been awarded to us.
इस क्वांटम पर हमें यहाँ पे नहीं डिसाइड कर सकते। आप कौन है? Is what you have to say.
The private respondent has to respond in this one. But I'm a formal party.
You are a formal party.
Private respondent is also appearing in the relation, but today he has gone for pay. From in the morning is gone for the county the election. He is a candidate.
Sorry?
He is a candidate since gone for the county.
ये चलेगा क्या आप लोग? आधा पूरा एक महीना. I am not going to acknowledge all this. He has gone for counting. ये किस तरह का submission? Very good. He informed. He is absent. Don't be his proxy, right? He is not required. Industrial disputes are given. एक महीना इलेक्शन का वो करेंगे कैंवसिंग और 2 महीना काउंटिंग के लिए बिजी रहेंगे, उसके बाद सेलिब्रेशन में 3 महीना। जिसके लिए आए हैं उसका कोई लेना ही देना नहीं है, ना लिटिगेट का कोई ख्याल है ना केस का कोई ख्याल है। Ready? Section 25C. Ready? Read it.
Right of workman laid off for compensation. Whenever a workman other than a workman has a claim on the procedural of an industrial establishment and who has completed not less than 1 year of continuous service with an employer is laid off, whether continuously or immediately, he shall be paid by the employer for all days during which he is so laid off, except for such weekly holiday and monthly pay compensation which shall be equal to 50% of the total of the basic wages and DNS allowance that would have been due to him and he had not been so laid off. Okay.
For the learned counsel appearing on behalf of the petitioner. Nobody appears on behalf of the private respondent. The learned counsel for the state is present. This writ petition has been filed for the following reason. पूरा में maintenance मांगे. The learned counsel for the petitioner is seeking mandamus to the writ petition although the petitioner is admittedly a workman under the provisions of Industrial Disputes Act, is seeking a mandamus from this court. And the fact remains that the petitioner had moved the presiding officer Labour Court of Jharkhand in ID case number 14 of 2019, whereby the petitioner had sought for a relief seeking a direction upon the private respondent for granting layoff compensation as enumerated under section 25C of Industrial Disputes Act 1947. And he has been granted compensation of at least 1 lakh. The findings of the award is quoted as under para 20, 21, 22. During the course of hearing, the learned counsel for the petitioner is unable to satisfy this court as to how a mandamus would lie. To which the learned counsel has submitted that that it has been mentioned in the prayer itself that the learned presiding officer Labour Court has failed to appreciate the provision of Section 2 capital A of Industrial Disputes Act arising out of Section 25 capital F.
Condition precedent. Notice period and all that has nothing been done in this case.
Layoff में तो नहीं है retrenchment. It is a case of layoff, not retrenchment.
But that
Layoff का 25 में कैसे apply करो?
in the case of retrenchment.
Retrenchment, not layoff, right? This court finds that the case, admittedly the case of the petitioner before the Labour Court was relating to layoff and claim was made under Section 25C of Industrial Disputes Act. During the course of hearing, the learned counsel for the applicant, the petitioner, has not been able to show any perversity in the improved award passed by the learned court, learned labour court.
Paragraph 20 is actually from the legal code error. Paragraph 20 at page 43. From the above facts which is available on report, I find and hold that the applicant is a worker of OP who has been orally discharged from his service as per M.1 para 16 during the crossing, and the OP is ready to take back in the original position as per paragraph 10 of M.1 and 2. Therefore, it is clear that the applicant, who is a permanent worker of OP, is orally terminated without giving any notice or holding any inquiry, and also without complying the provision of section 25C of the IDA.
So the provision of section 25C was not applied.
You filed an application for 25C only. That was your case.
Yes, sir.
So you filed an application for compensation under section 25C of the Industrial Disputes Act. That was your case.
Yes.
The petitioner had filed a petition seeking relief under section 25C of the Industrial Disputes Act, and he was granted relief of compensation. He had joined the service on कब join किए थे?
2/1/2017.
2/1/2017. And as per the case of the petitioner, he was laid off since 12/8/2019 onwards. ये कब केस फाइल की? 2019 में ही फाइल की।
Yes. ID case was filed in the year 2000.
The case was filed in the year 2019 itself. No perversity in the improved judgment as such has been pointed out. This is apart from the fact that the petitioner has sought a mandamus from this court. Commanding upon the respondents to pay the wages for the period from 12/8/2019 till 25/2/2019. This court does not find any merit in this petition, which is here dismissed.
So that I can approach for a filing the execution.
Private mandamus का वही
The execution for that award amount, awarded amount.
उसके लिए कुछ जरूरत नहीं है लेबर का, you go and तुरंत हो जाएगा execute.
That order. As far as that awarded amount is
To
released,
this, the counsel for the petitioner has submitted that
as far as that
an observation may be made that the petitioner may get the amount awarded by the labour court by initiating an appropriate process of law. this court is of the view that it is certainly open to the petitioner to get the award executed as per
DPO.
as may be permissible under.
Item 43, WPL 5027 of 2025.
Why do you need a recall of the matter?
So, well, that was that we have got an order to serve the notice through the lawyer in the tribunal, but before we could comply with the order, they have entered appearance. So that was we are not
I
present.
number 1019 of 2026. Counsel for the petition submitted since the respondent has already appeared, the interlocutory application has become infructuous. IA number 1019 of 26 is dismissed as infructuous. Ms. What else?
Yes. Let me say that needs no compliance actually because they have appeared this order dated 4/12/2025 needs
Has become infructuous and
the order
since the respondent has appeared, the which order?
order dated 4/12/2025.
Order dated 4/12/25 with regard to personal service upon the respondent need not be complied.
Yes. Now, not in the merits of the matter, kindly come to the impugn of the proceeding which is pending. The workman has been dismissed. He initiates a proceeding under section 2 capital A directly. Now, during pendency, because I am not going to the backgrounds of earlier orders. Now, kindly look at the order, the operative portion at page 30. In view of the above facts.
There was a petition filed.
Yes, there was a petition.
Where is that petition?
Yes, petition, your lordship will see at page 26. Now, this is marked by suppression of facts, which I will show, but it's a question of jurisdiction.
No, what is it?
He files a petition seeking protection from dispossession from the official quota and change of service conditions. And that medical facility should not. A dismissed workman, number one, factually he has already been dispossessed. He went to the HRC, withdrew because he was dispossessed. Number two, medical facilities and other service conditions. So far as a dismissed employee can't. There is a separation of relationship of employer and employee. How can that interim order be passed that you continue to give him those benefits?
The Labour Court has power to grant interim relief.
No, there is no provision in the Labour Code to grant interim. Morgan Stanley says if a tribunal is not vested with the power to grant interim relief, then it can't grant interim relief. But there is an income tax judgment which says that tribunals and courts may have inherent power. I am not going to do that. But it has referred to section 33, which is not applicable to a case of dismissed work. Your Lordship is absolutely right to ask me a question whether there is a power to grant interim relief. Morgan Stanley Supreme Court says no. If you like consumer courts, it was a case arising from a consumer court.
What is the stage of the case?
Stage of the case cannot say is that
11A ka?
11A the inquiry has been held to be fair and proper. Now the documents will have.
How much time does it take?
It does not take much.
Why don't you get it done?
We have no things and it is to be decided. We have no action. Kindly 33 may kindly visit. Since the relations of employer and employee has not been come into end due to the
No, it has not come into end.
kindly come to the definition of workman. I am a workman. As per the industry.
You have not been terminated.
Well, kindly come. Terminated employee includes as a workman. Kindly come to the definition workman. Section 33S. Sorry, 2S.
That is for the purposes of invoking the.
Kindly for all purposes. Kindly workman.
Two S.
That has been considered by the court. workman.
Yes.
Workman means any person, including an apprentice, employed, or in any industry, do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward, whether the terms of employment be express or implied, and for the purpose of any proceeding under this act in relation to an industrial dispute, include any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute, or whose dismissal, discharge, retrenchment had led to dispute but does not include any such person. So other things.
No, this is only to confer jurisdiction to the labor code, that labor code shall entertain such disputes.
That is 2A.
No.
Yes.
No, workman, you see, unless a person is workman, he is disputed.
My submission advertising consider that
And
for the
includes
purpose
such
it is not
person,
my lord.
and includes such person who has been dismissed, discharged, or retrenched.
Yes, I have been dismissed. And therefore, I am as a workman. Therefore, any service condition which is at the time of my service cannot be changed. And as per the service condition, I have been provided with a quarter and a medical facility that cannot be withdrawn. And the same has been done. Therefore, an application was filed that has been allowed. And that will allow by a reasoned order. And I am still a workman. And therefore, service condition cannot be changed. And for which there is this section also.
Section 33.
Yes, section 33 and subsequent also.
Which section? Apart from this, which section are you relying upon?
33A. Special procedure and justification as to whether condition of the service etc. changed during the pendency of the proceeding. 33A. Special provisions for adjudication as to whether conditions of the service etc. change during pendency of proceeding. Where an employer contravenes the provision of section 33 during the pendency of the proceeding, if at proceeding, because then an employee agreed by such conduct may make complaint writing in manner to such consideration. There is a provision for changing of the, but there
Let
is no
us see section 33.
My lord?
Let us see section 33.
Yes.
Because the condition precedent is contravention of section 33.
Yes.
You read section.
They have not filed any application of conciliation option.
You read section 33.
Yes. The condition of the service duty to remain unchanged under certain circumstances during pendency of the proceeding. During the pendency of any conciliation proceeding, before the conciliation officer or board, or of any proceeding before the an arbitrator or layer court tribunal or national tribunal, no employer shall, in regard to any matter connected with the dispute, alter to the prejudice to the workman concerned in such dispute the conditions of service applicable to them immediately before the commencement of such proceeding. Next, for any misconduct connected with the dispute, discharge or punish, whether the decision or otherwise any workman concerned in such dispute, save with the express permission in writing or authority for which the proceeding is pending. No permission has been taken. During the pendency of any such proceeding in respect of
What is the condition of service?
Well,
What is the condition of service? I'm just asking you. What is condition of service? Allotment of this quarter is a condition of service.
that has been written. That is one of the my service content. I was awarded with a quarter or given with a quarter and medical everything. That is also one of the. Not exactly, I cannot say that it is a service condition, but it is a
service conditions would include something like salary, wages, increments,
salary
leaves. So therefore, my learned friends, going by his logic, a terminated worker must continue to get wages.
No.
Yes. That is what.
I am not saying that.
Then what? No condition. There should not be any change in condition of service. It means that if he was getting 1,000 rupees on the date of termination, he should continue to get that till your case is adjudicated.
That is salary is different thing, but the
salary is
different.
You see, these perks are all parts of salary.
The perks, yes, part of the service.
These perks are all part of salary.
because there is a simple answer to what my learned friend has actually read. If there is a violation of section 33, then he should have not filed the application, interlocutory application, he should have filed for section 33A.
Yes.
Now that
there is a separate provision under section 33A. You can file a separate petition.
It is to be employer to file application for changing. That is the section.
No,
Yes.
you are not getting it.
Madam,
Just a moment.
Yes.
If there is a violation of section 33,
Yes.
you have a remedy to file a petition under section 33A. And they are also supposed to be punished for that, for changing your service condition. उसमें एक criminal case भी होता है ना?
होता है. So let him
And they have to take on permission also for changing any service condition.
वो permission लिया नहीं लिया क्या किया वो सारा कुछ आपका 33A के proceeding में. That itself is a separate industrial dispute. But in a pending industrial dispute, how can such a petition be entertained and passed?
But section says otherwise.
Which section says?
33A. Where an employer contravenes a provision section 33 during the pendency of the proceeding, any employee agreed by such.
Any employee by such contravention may make a complaint in writing in a prescribed manner to a such conciliation officer report. So यहाँ नहीं है
That is why I made an application.
No, it is not.
That is why I made an application before the conciliation officer or the tribunal, and the same was allowed. And same was allowed by the.
What is the consequence of violation of, say, I've forgotten all these provisions right now.
Consequence of violation of?
Section 33A.
No.
A complaint is filed.
Then adjudication is done.
Adjudication
and then order
is
will
done.
be passed.
Yes.
And then order is passed. And now what is passed? What is to be done? Now suppose a person has been transferred, and it is found that during pendency it has been transferred. Then it is transferred to the citizen. So it's only a separate proceeding to see that there is no victimization on account of the fact that an industrial dispute is raised.
I remember there is some kind of punishment.
हाँ वो तो है 29 में है क्या और
29
में Penalty comes towards chapter 6 is penalties. And then we'll see any award which is breached minors, including a 33 award. Because so an award is made under 33A. Then if it's not compliance, then a punishment is under section 30. Now kindly come to 31. Directly notes. Kindly come to 31. There is a specific provision for violation of 33.
Penalty, yes.
Yes, penalty for other offences.
But I have.
No, there is a violation provision. You have two remedies. One is go under 33A to get a substantive relief, or go under 31 to get a punishment.
Who contravenes the provision of section 33 shall be punished with imprisonment.
Yes. So there are judgments which say that it may have to, why it has to precede an award and adjudication before a penalty is imposed by a court, because the criminal court will not get into the correctness of such.
This is still there is no award. It is still pending.
Let us see the interim order.
Yes. Starts at page number 32.
Let me see your answer also, to respond to the question. You must have raised your 5 points.
That is at page 28. That's all fact. May I just place that the contents of paragraph 1 of the petition are denied. The workman has referred to section 33 of the industrial dispute without understanding its scope. Section 33 applies only where there is an employer-employee relationship and where the employer changes the condition of service of the workman with pendency of dispute. In this case, the workman has already been discharged from service after proper inquiry. Therefore, the question of continuing service conditions does not arise. Then in paragraph 2, the workman has falsely alleged that the company forcibly evicted him from the quarter. The fact that it is that the workman voluntarily surrendered the quarter after separation from service. Regarding medical facilities, it is respectfully submitted that free medical attention is available to employees and their families in the general ward of the company's authorized hospital and dispensaries. After discharge, the workman is no longer an employee of the company and hence he was no longer eligible under the standing orders of company policy. There is no provision for continued medical benefits post termination. That paragraph 3 of the petition is incorrect. The workman has stated that there was no standing order in the company is wrong, which is wrong. As per the law, even if certified standing orders is not in place, the model standing orders under the Industrial Employment Standing Orders Act 1946 are automatically applicable. Therefore, the conduct of the employer is governed by law at all relevant times. That paragraph 4 is also wrong. The workman has said that the standing order were framed only after his termination in 2019, but it is submitted that the certified standing order was certified by the Joint Labour Commissioner on 29/11/2017. The company has clear rules in the standing orders under clause 29E. The use of company's quarters is conditional on the employees being in service of the company. On termination of the service of an employee for any cause whatsoever, he shall give up his quarters immediately and will be liable to be removed if he fails to do so. That is, Tulakadu, Manakira, Sripurko, Gundur and others, so the Andhra Pradesh High Court held inter alia that occupation of quarter by the employee which is not one of the service conditions and as such section 33A of the Industrial Dispute Act has no application. It is therefore submitted to the workman neither has any right to be in possession of the quarter nor entitled to any facility post termination. That in ABC was state of Jharkhand, Jharkhand High Court held rather the pure and simple question involved in this case is as to whether on the day when the company's petition was filed, the petitioner was in active service of the company or not. If his services were terminated, he was not entitled to retain any property or quarter of the company. The judgment really applies to the present case. The worker was not in service at the time the petition and hence cannot claim restoration of the quarter or continuation of facilities. That it is submitted that the above judgments take before the residential quarters cannot be retained by employees or workmen after termination or superannuation. It is also relevant to mention that the company has specific rules regarding vacation of quarters and withdrawal of medical facilities which may apply uniformly. As per these rules, both quarters and medical benefits are available only during the period of active employment and after surrender or discontinued upon cessation of service. Therefore, no right survives in favor of the workman to claim continuation of workmen of such facilities after discharge. That in the present case, the prayer of the workman for restoration of water and medical facilities is not maintainable in law. These facilities are
You see,
not.
none of your contentions has been considered in
Not-
that.
Neither
These
these-
judgments, these contentions have not been considered.
One judgment was considered, it was
Which has been considered?
it was ABC versus the state of Jharkhand was considered, and it has
One
really-
judgment you forget about
one judgment considered by saying that and it was-
The service conditions have been considered.
My lord,
Because you say that there is a violation of service conditions.
it was not. It has
Where
not
is
been
it?
discussed. It has not been discussed.
Not
But
discussed.
that judgment has been given, but it was case related to the superannuation of the service.
That's right.
And that is
Okay, forget about that. One judgment was misplaced. Where is the discussion of condition of service? Where is the discussion that your quarter and this medical facility is a part of your condition of service? And you are and as per this condition of service, just a moment. And as per the condition of service, you are entitled to continue with that in spite of termination. That should also be a.
that has been considered.
You see, you continue to be a this is just I don't know why such an order has been passed.
We couldn't understand why the Labour Court passed such an order because this is the first time I have also come across such an interim order that you continue medical benefits and giving quarters which is already dispossessed.
Then under such circumstances you are entitled to an entire salary also.
That's what I'm saying.
No, why did you ask for salary?
It was not a question. It is not. That was not
That is also a change of service condition because now you are not getting any salary. Are you getting salary?
But
then you will say my PF should be deducted, my this medical allowances or whatever, all these things should be
If
deducted.
the purpose of the regulation is completely gone, if this interpretation is accepted today, then there is no point.
And you have evicted. Just a moment.
Why don't they conclude
Just
this
a moment.
proceeding and?
ये तो हम बोले तो आप तो उखड़ गए, समझ नहीं आया आपको?
नहीं हम तो सुई बोलेंगे it should क्या क्यों नहीं क्या I don't know but it should be concluded.
वो तो हम करा ही देंगे conclude तो यहाँ आने से हो ही जाता है। लेकिन ये ऑर्डर का क्या करें? इसको तो डिसाइड करना
बाहर ही है सेवी restoration for a.
And it is status quo.
It is not that I am in possession of the quarter. It is not. I am not in possession.
Yes, you have voluntarily evicted. This is what they have said.
Voluntarily evicted. They have evicted them when they come because non-eviction is a penal provision. Therefore, it ought to be. Then I have filed application why I should not have been evicted, and that was considered.
Evicted means आपने खाली कर दिया ना?
ऑर्डर अगर ऑर्डर होगा तो क्यों खाली नहीं करेंगे तो वो प्रोसिक्यूशन स्टार्ट करेंगे लेकिन आपका खाली करने के बाद में एज ए गुड सिटीजन हम खाली कर दिए उसका एप्लीकेशन दिए
बहुत अच्छा
So he has evicted is an evicted fact from para 2 of his own petition.
Yes. उन सोचें से कितना
Give you a short note by tomorrow morning. On jurisdiction and all judgments. Extract all judgment. I just placed judgment on Morgan Stanley, which was a Consumer Protection Act, which the Supreme Court at para 44 says a careful reading of the above, that is section 14, discloses that there is no power under the Act to grant an interim relief, even an ad interim relief. Only final relief could be granted. If the jurisdiction of forum to grant relief is confined to the four clauses mentioned under section 14, it passes our comprehension as to how an interim injunction could ever be granted disregarding the concept. Here, we have n number of judgments which say that the industrial court or labor court can only answer the reference. Yes or no. It can't pass any other.
It can't pass any other order. Is it a reference case?
Yes, but 2A hai, but 2A is a deep reference provision that whether the termination order is good or bad. So the finally see the scope of section 2A. You can't go beyond 2A. I will make a small note. I have also understood. I will answer his.
DB में BCCL वाले matters में हम इसको decide किए थे. That was my judgment. We upheld also by Supreme Court. Section 33 का scope, how the proceeding is done.
वो 33C2 का.
नहीं. 33C2.
ठीक है. I will do my. I will get that hold of the judgment.
हमको जहाँ तक ध्यान है. 33C2 नहीं था.
अच्छा 33 था.
33. ठीक. यही तो अपील कर रहे थे. You were appealing.
23 का अगर कोई पेंडिंग प्रोसीडिंग है,
हाँ.
जैसे कोई ओवर टाइम का कोई वर्कर का कोई प्रोसीडिंग पेंडिंग है, उस बीच अगर हम टर्मिनेट कर रहे हैं,
हाँ.
तो अब होगा. और अगर डिसमिसल और डिस्चार्ज अगर हम कर देते हैं, तभी हमको इंडस्ट्रियल एक्टिविटी से अप्रूवल एप्लीकेशन लेना होगा. अगर डिसमिसल, डिस्चार्ज और रिमूवल, ये तीन चीज को छोड़ के अगर हम कोई भी चीज करते हैं, तो उसके लिए हमको इंडस्ट्रियल एडजुकेटर से अप्रूवल एप्लीकेशन लेने की भी जरूरत है.
I will not incorporate those because that is not applicable. The only question is 33 will not apply to a case of dismissal or discharge.
You see, I am convinced that this order has to go. But the point is that such order should not be repeated.
Your option wants to lay down.
Yes, certainly.
So I will minus give a
on the point of interim relief, whether any interim relief can be granted.
I will just make a note and try and.
Because it is a kind of, it is in the nature of interim relief. Then status quo ante, मतलब already you has already evicted.
This is a mandatory temporary injunction.
Yes.
Which the Supreme Court says you have to make out more than a prima facie case.
You give the note by tomorrow. I do it by day after, right? Arguments have been concluded. आपको भी देना है. I'm not saying कि ऐसी बात नहीं है कि आपकी बात नहीं सुनेगा, आपकी बात नहीं सुनेगा. याद नहीं, बहुत दिन हो गए, 1-1.5 साल हो गया, वो याद नहीं. That was authored by me only. Post this case.
LP 446 of 19.
That's right. LP 446 of
19. 10 number of judgment सिंगल में बैठ के किया होता है उसको फॉलो करके
this case को direct
Instead of tomorrow,
Yeah.
day after.
you give it by tomorrow.
Day after. As थोड़ा सा
Tight.
Tight for other reasons, not work. Work is never coming in some personal difficulty. Today.
You will give by day after tomorrow.
Tomorrow morning. Day after tomorrow.
Day after tomorrow morning.
Yes, I'll give.
तो उसके next day रखते हैं.
जी Thursday.
Tuesday, Wednesday, Thursday. Thursday 10:30 first case.
Very good.
बोर्ड ओवर हो गया. आज तक मेरा तो कभी ऐसा नहीं हुआ. This never happened in my life.
Part of history.
Yes, you are part of history. हम इतना कम केस लगाते ही नहीं है कि बोर्ड ओवर.
Because the roster is such.
फर्स्ट अपील तो है मेरे रोस्टर.
Next case. Second one is it. But that's what we are talking outside now. One judge has three rosters, four rosters.
क्या करेंगे, जजेस नहीं है. जो भी है, उसी whatever work comes by is required.
No one is blaming the judges. We only feel that
वो एक सब्जेक्ट से दूसरे सब्जेक्ट में शिफ्ट होने में you take time. I was in WPL roster for quite some time. Disposed of many cases. In LPA also I disposed of many cases. But इतना retain करना नहीं possible. The nuances of law you just can't just retain in your memory. मेमोरी में भगवान को याद करने के अलावा किसी को रखने का जरूरत नहीं.